You know, this definitely throws a lot of questions about the judicial system in the country, because now he's been acquitted. He's a free man, as a matter of fact.
Yes,
the court has seen him. He has done no wrong whatsoever. So what will be the immediate actions you expect to see? For instance, if you say that some heads must roll, where should it start from?
Yes, Gimba, I said it repeatedly. The court is not a Father Christmas. It is not about the judiciary. It's about what you establish. They say our laws, our constitution presumes you innocent until the contrary is proved. And so what that means is that it is the responsibility of the prosecutor, the investigator, to establish beyond reasonable doubt in the mind of the court that this man actually committed the offense, that anybody that hears the story, the only conclusion that will come to his mind is that, yes, this man did it. But if you're unable to establish that nexus, it is no longer a business for the court. What the heads that should be rolling is the heads of the investigator and the heads of the prosecutors, because the prosecutor failed to direct the investigator on the evidence that will grant conviction. And even though they don't have such evidence, there's no statute of limitation to criminal matters. You don't have such evidence and you rush to court. You give the impression that, yes, you have it all wrapped up, only for us at the end of the day, at the end of 1,080 days, we are back to this. And then the man is saying, look, I was being victimized because, I didn't play along. So it is not the first time, it's not the second time, it's not the third time, because we refuse to use prosecutors and investigators as example. Money would have been spent by the state, by the way, to prosecute this matter. A lot of funds would have gone under. And so who accounts for those?
You know the ramifications of this kind of case that we have seen dragged on for so many months, running into even almost a year or so. But if we have to weigh that as against preventing such kind of scenarios from happening in the future, for instance, do you think that such cases can be backed up by the law and give them that solace that you cannot take me to court if you don't have full evidence? If not, you will have to face the kettle as well.
Yeah, because, as it is now, Saraki can go to court. Saraki can drag the EFCC and the federal government to court and claim damages, that he was being persecuted, that even though they have no evidence against him, they have no link. But because we don't do that, if we're in a society where things like that are done, you know how much this will cost the federal government. And so to deter prosecutors from rushing to court when they have not concluded, gathering evidence, there's need to take steps in that direction. And then also, since it is obvious now that once a man steals, it is difficult to recover. What we should do is to put structures in place that will deter people from even dipping their hands in the till, rather than allowing them to dip their hand. And at the end of the day, it becomes even difficult to take from them what they have grabbed. Because
Liberus, let me put you on hold for a minute or two and bring in Monday Ubani, the second vice president of the Nigeria Bar Association. I want to thank you so much indeed for joining us on State of the Nation. You've been following this story as well. And were you surprised, by the way, when you heard the acquittal of the president of the Nigerian Senate?
Surprised, yes, I was a bit surprised because the Court of Appeal at the last judgment, said that 3 of the 18 count charges should actually be tried afresh at the lower court. So I know they gave reason why they felt that there was enough sufficient evidence that will warrant the trial for the 3 count charges. But well, the Supreme Court is the final court of the land. The Supreme Court says, well, we upheld they upheld the no case submission that was actually upheld by the lower court, and then of course did not agree entirely with the judgment of the Court of Appeal in ordering the trial of the 3 count charges. So that is actually what has happened. So it's the Supreme Court, and they mentioned the issue of witnesses. The vital witnesses were not called. Very important. And they also mentioned the fact that the documentary evidence that was actually tendered in court were not actually done by the makers of those documentary evidence. And these are key issues that has to do with investigation. The moment you don't develop skill and specialization in investigation, especially in crime that has to do with financial issues, you have cases like this being decided by the court, throwing it away. Let me tell you this. There is a philosophy behind criminal jurisprudence, and that is the fact that it is better for 9 accused persons who are guilty to go scot-free than for one innocent person to be convicted of an offense he never in any way committed. That is the idea behind criminal jurisprudence. So the moment any doubt is raised in the mind of a judge, when the evidence is not sufficient to convict an accused person, he will always resolve that doubt in favor of an accused person. And that's why we are saying that the issue of specialization and skill in investigation of crimes, especially financial crime, should actually be developed in our system.
When you look at the developments that have taken place in the recent past, especially to do with the corruption watchdog, the EFCC, and some of the cases that it's been able to prosecute, but one will want to ask that question: how well is the EFCC itself equipped to, have that caliber of lawyers that can represent it in terms of cases that are so sensitive, like a state case like this one?
Now, the issue is that when the president of the Nigerian Bar Association was sworn in, and that is Mr. Ebi Mahmood, senior advocate of Nigeria, one of the things he suggested, even though he was misunderstood, is that, look, EFCC can go ahead to develop some level of skill and competence in investigation by engaging in training and retraining, but they should also not in any way participate in the prosecution. They should allow specialized group or specialized people to handle issue of prosecution. In other words, there should be a difference between investigation and then assembling of evidence and then people that will prosecute the offenses. And so that has been the suggestion. And I think that is something that is worthy for us to take a note of and then begin to probably do it in that manner. An agency that does the issue of investigation and also contributes in the issue of prosecution may have conflict of interest, and most times there may be an issue, and that's why we're having most of the cases being dismissed in such a manner that Nigerians are not finding very funny, and of course they will keep on blaming the judiciary.
Ondobani, I want to thank you so much indeed for sharing your thoughts with us, as well as Liboris Oshoma, a lawyer. Unfortunately, I cannot get back to you, but I do sincerely thank you for talking to us on State of the Nation. We'll try to make it another appointment at some point. You're watching State of the Nation. We're going to take a short break now. When we return, the IDPs are facing lots of concerns, especially in the north-central part of the country, especially in Benue State. Again, we're going to x-ray that in just a moment. Join us again.